The government, that's the DWP in this context, is very much concerned to improve governance in pension schemes generally, but in particular in DC schemes. And this is the underlying strategy behind the pension regulators' focus on 21st century trusteeship and raising standards. The government thinks that there are just too many small DC schemes out there that are poorly governed and don't get the best member outcomes. And the trouble is with DC schemes, if the governance is poor, if the range of investment options is not good, if the charges are too high, it's the members that suffer. There is no employer covenant to fall back on. Well, you can do transfers in a pension context, either with member consent or without member consent. And clearly there are problems with getting member consent. You can't find the members or they're not particularly interested. So the without consent transfer, if you can meet the legislative requirements, that means you can transfer all the members. There aren't any people left behind. The issue is that the legislation dates back to 1991 and it was essentially designed for DB schemes, and you need an actuary certificate as one of the conditions that has to be met to do a without consent transfer. And that doesn't really fit very well with DC schemes where they don't usually have a scheme actuary. So the legislation was changed with effect from April this year to allow different ways of doing DC to DC transfers without member consent. Well, under the new regulations, there's three options. The first is a transfer to an authorised master trust. The second is to a scheme to a scheme of an employer that's connected with the employer of the scheme that's transferring. The third is where the trustees receive advice from an appropriate advisor, who's a person that's skilled in pension scheme management. Well, I think master trusts are going to be the most significant beneficiaries of the change to the legislation, because it goes hand in hand with the new authorised master trust regime. And essentially, trustees who may otherwise be concerned about committing their members' benefits to a new provider will receive a degree of reassurance that the master trust operation has a strong and effective governance framework, has a better range of investment options possibly, and hopefully also better charges applied. And where trustees are deciding whether or not to transfer to a new arrangement, I think it's very likely, even though with master trusts the only criteria is that it is an authorised master trust, I think it's likely that they'll take advice from an expert, a pension scheme manager, and they will get the degree of reassurance that they need that's referenced in the DWP's guidance on this topic, that is a safe and effective vehicle to transfer members' benefits to.
So when the DWP have looked at the consolidation market, what they've found is that there's a large number of small DB schemes out there. So, for example, over 1/3 of DB schemes have less than 100 members. And so the DWP have looked at this and said, well, actually, there's a lot of scope here and particular advantages if these can be consolidated. And there's kind of three particular reasons to note in relation to the benefits of consolidation. So first of all, efficiencies in relation to economies of scale and governance. So I guess put simply, if these schemes are kind of merged together, it should reduce costs and also improve governance if they're larger schemes. Secondly, in relation to investments, it would mean that new kind of investment options are available that apply to larger schemes, and also that it should be able to bring kind of lower costs in relation to those investments. And then thirdly, in terms of a final reason, the DWP recognise that employers are there and they're often kind of distracted by their DB schemes and distracted away from running their business. And so part of the intention with consolidation is that employers might be released from looking after their schemes and can focus on their business. And in terms of when the DWP are looking at this, their view is that they're going to consult on it kind of later this year, and then their aim is that in order to kind of streamline the legal process, that new legislation will be introduced because the current legislation doesn't really fit and allow this consolidation to occur. DB consolidation has existed for a number of years in various forms, but I think one particular distinction between what's being proposed in the future and the current model is that in the current model, the employer always has a link to the underlying pension scheme that it originally sponsored. And in relation to the future and the new model, the way that the DWP want the legislation to work is that it should be very broad in terms of not specifying one particular format and method and approach that needs to be adopted in relation to future consolidator vehicles. And this is something that we're already seeing in the market in terms of the different approaches that are being adopted to consolidation. So for example, there's one provider called Clara who are looking to enter the market and offer the option of schemes entering it. Each scheme will have its own section with the assets being segregated for those particular members. And the aim with Clara is that the members' benefits will be bought out at some point in the future. And another kind of provider that's looking to enter the market is called the pension Superfunds, and that operates a very different model. So in that model, the assets will be pooled with other schemes that enter it. There isn't any kind of long-term aim of buyout. It will just be run off in the future. And in relation to that model, it's really looking at the benefits of economies of scale and different kind of investment options in terms of profitability and operating in the future. But I think what's really interesting in terms of those two options is that neither of them kind of fully address the DWP's kind of concern, which is around these smaller schemes with less than 100 members. They're both catering for larger schemes. And so it's going to be interesting in terms of kind of what other providers enter the market. We know that there are other providers that are looking to enter and are looking at in particular at the capital requirements and funding. And so it'll be interesting to see what other kind of models they adopt and when they can join. So the DWP published a white paper earlier this year, and they're going to be publishing a consultation in the autumn. And I think the issues that the DWP are raising can be grouped into three main areas. The first one relates to governance, the second one in relation to the role of the employer, and the third one surrounds kind of funding. So in relation to each of those, in relation to governance, the DWP are looking at some form of authorisation regime in a similar way to DC mastertrusts, and also applying certain specific kind of governance requirements. And that's really just recognising that it could be tens of thousands of members who are in these schemes, and so they need to be run properly. In relation to the second area around the employer, I mean, that's a really kind of key area, which it really kind of centres upon the fact that if this is going to be a break between the employer and the pension scheme, then what specific kind of protection needs to be included around the regime to allow that? And should there be any comeback in the future to the employer if the vehicle ever failed in the future? The third area, funding, I think is the largest area in terms of issues to consider. So it's around what funding level is required to enter the vehicle, are there particular kind of capital requirements that can apply? What are the issues to consider if the provider of the vehicle wants to extract profit in the future? When should that be able to occur? How should the assets within the super fund be invested? So there's a number of issues there that the DWP need to consider, which really surround the fact that from their perspective, they don't want schemes to be entering these vehicles and for there to be some kind of failure in the future. I think the main issues if you're entering a consolidator are really kind of issues for the trustees. So from the trustees' perspective, it's a one-off decision to enter into the consolidator. And I think from their perspective, it's looking at, well, do we swap the covenant that we've got in the security of the employer for the security that applies in relation to the vehicle that we're moving into? And it might also be that the employer might be offering, certain cash to as a one-off kind of payment to be able to enter the consolidator model. And so for the trustees, they'll be looking at that and going, well, do we enter this consolidator, give up the strength of our employer covenant? And also, they might also be thinking, well, actually, have we got a potential to reach buyout and to be able to buy out our pension scheme in the future? And if we enter into this consolidator model, such as the pension superfund, then there is an expectation that we'll be buying out. And so the trustees will be thinking, well, in terms of our members' best interests, and thinking about how can we ensure that members receive their benefits at the end of the day, which is the best option in terms of our existing employer, and entering the consolidator model. I think from the employer's perspective, I think their concern would really be around, primarily, if our pension scheme enters into this consolidator, does that really break the link that we have between the pension scheme that we have at the moment, especially if the employer is paying in additional cash to enter the consolidator model? And so from the employer's perspective, one of their key concerns will be applying for clearance from the pensions regulator, which will confirm that there won't be any comeback to the employer in the future. If people require more information, please contact either Chantal Thompson or Jonathan Sharp at Baker McKenzie.